Welcome back, future lawyers. Today, we're diving straight into an explainer that's going to totally decode one of those absolute rock-solid foundational doctrines of contract law. I'm genuinely thrilled to walk you through a case you are 100% guaranteed to encounter in your 1L contracts class. We are going to break down the actual mechanics of consideration, and we're doing it by looking at a true landmark judgment from way back in 1880, Durga Prasad versus Baldeo. My goal here is to take all that clunky legal jargon and transform it into a crystal clear visual structure so you can really master the logic behind the law. Okay, to get our minds in the right analytical headspace, let's kick things off with a hypothetical. Imagine this. You spend your own hard-earned money building a bustling marketplace, and you do it simply because a local official requested it. It's a massive investment on your part. Later on, the shopkeepers who move into your shiny new market, well, they promise to pay you a commission on their sales. Awesome, right? Everything goes smoothly for a bit, but eventually, they just flat out refuse to pay. So here's the big question. Can you legally force them to honor their promise and actually pay up? Well, this isn't just some fun little brain teaser. This exact scenario was the beating heart of Durga Prasad versus Baldeo, which was decided in 1880 by the High Court of Judicature at Allahabad. This historic case is a real game changer because it laid down a definitive rule about exactly how promises become legally binding contracts in India. It basically draws a giant, hard line in the sand between what's just a moral obligation and what is a strict legal duty. So to structure our analysis today, just like a classic case brief, we'll hit these 5 points: the marketplace dispute, the core legal issue, plaintiff versus defendant, the court's reasoning, and finally, the legal principle established. Let's get right into it. Part 1. The marketplace dispute, a promise made and broken. Now, you know as well as I do, isolating the timeline is literally everything in contract law. So let's look at step 1. The local collector, an official who's just trying to encourage trade, orders the market's construction. Moving to step 2, our plaintiff, Durga Prasad, acts on that instruction and actually builds the shops with his own money. Then we hit step 3, which is where our defendants enter the picture. The traders, including a guy named Baldeo, occupy the shops and agree to pay Durga Prasad a commission on their sales. And finally, step 4, the trigger for the whole lawsuit. The traders default on their payments. Now, really notice the disconnect here. The person who asked for the market to be built is completely different from the people who ended up using it and promising to pay for it. Part 2, the core legal issue. What is the court deciding? All right, so here is the crucial point we need to zoom in on. Under the Indian Contract Act, could the construction of that market serve as valid consideration to legally enforce the trader's promise to pay the commission? Remember, in contract law, consideration is essentially the value given in return for a promise. It's the core bargain, right? Durga Prasad wanted to force the traders to keep their promise to pay him. But for that promise to have any legal teeth, he had to have provided valid consideration in return. So was his act of building the market enough? Moving on to part 3, plaintiff versus defendant, clashing perspectives. Let's look at how the battle lines were drawn. The plaintiff, Durga Prasad, comes in making an argument that leans heavily on fairness and logic. He's saying, look at all this substantial money I spent, and look at the massive direct benefit these traders enjoyed from my newly built shops. Because of that, he argues, their promise to pay him absolutely must be fulfilled. But in stark contrast, the defendants rely on a very strict mechanical reading of the law. They point out one single glaring fact. The collector instructed the construction, not them. Since they never actually asked for the market to be built in the first place, they argue there is absolutely no valid consideration and therefore no legally binding contract whatsoever. That brings us to part 4, the court's reasoning, breaking down the logic. So the judges had to untangle this, right? They had to weigh 2 totally distinct concepts. On one side, you have the benefit received, and on the other, you have the desire of the promisor. The court freely acknowledged the first part. Yes, the traders clearly received a tremendous benefit from the new market. There's no denying that. However, the judges determined that simply receiving a benefit is a completely different animal from the promisor actually desiring or requesting the act. Contract law isn't just about who gets a good deal. It's about what was actually bargained for. Since the traders never asked for those shops to be built, the act of building them just wasn't driven by their desire. And the results of that strict, logical separation? It was pretty devastating for the plaintiff. Because the market was constructed entirely under the collector's instructions and not at the request of the traders, the court tossed Durga Prasad's claim completely. The agreement was ruled totally unenforceable because it fundamentally lacked the valid consideration recognized by the law. Finally, part 5, the legal principle established, the rule of law. Okay, Here's the strict, foundational definition we extract from this case, and it's one you should honestly just commit to memory. For an act or promise to be valid consideration, it absolutely must be done at the desire or request of the promisor. A purely voluntary act, or an act performed because some third party requested it, like the collector in our story, ordinarily cannot serve as consideration for another person's subsequent promise. The law demands a direct link of desire between the person making the promise and the act they are actually paying for.
And this concept isn't just floating around in common law theory. It's perfectly crystallized right there in the statute itself. If we look at Section 2D of the Indian Contract Act of 1872, it explicitly mandates that consideration absolutely must move at the desire of the promisor. The exact words of the statute perfectly mirror the Allahabad High Court's reasoning. Basically, if there's no desire from the promisor, there's no consideration. And it doesn't matter how much blood, sweat, or money the other party put into it.
To wrap up this explainer, let's hit your key takeaways as law students. They're simple and clearly laid out here. Number 1. Someone merely benefiting from your actions absolutely does not create an enforceable contract unless they specifically asked you to do it. Number 2, third-party requests, even if they come from powerful government officials, do not bind the promisor. And finally, just realize what a huge foundational precedent Durga Prasad versus Baldeo really is. It teaches us to always look for the desire behind the act when evaluating if a true contract actually exists. Before you head to your next class or study session, I want you to ponder this little twist on the facts. What if the traders themselves were the ones who secretly petitioned the collector, asking him to issue the order to Durga Prasad? In that scenario, where the origin of the request completely changes, would the consideration suddenly be valid? Would the act of building the market then be moving at the desire of the traders? Think about how a tiny shift in the timeline and the flow of desire could totally flip a court's ruling. Thank you so much for joining me for this explainer. Keep asking these tough legal questions, and as always, keep looking closely at the details.